Hello and welcome to TechLawyer. Today we are discuss Article 14. So let's see what is given in the Article 14. As per the Constitution, equality before the law. The state shall not deny to any person equality before the law and equal protection of the law within territory of India. This is the given definition under Article 14 as per the Constitution of India. Now let's break it. So what is the meaning of equality before the law or the equal protection of the law? So Article 40 of the Constitution of India lay the foundation of the concept of equality before the law and the equal protection of the law. It stated that the state shall not deny to any person equality before the law and equal protection of the law within territory of India. Article 14 is a fundamental right that ensures that every individual, regardless of their background, is treated equally by the state. It's prohibited discrimination and arbitrary treatment. That means this is not specific for the Indian citizen. It's like all the people. Maybe they are citizen of India or not. They are apply for all. Okay. So this is the flow chart you can see over the screen. Article 14, equality before the law, equal protection of the law, and access to justice. So equality before the law is not absolute. It's similar to the rules law, and equal protection of law is a positive concept. And access to justice means equality in the front of the judicial system. So this is the flow chart which is show the flowing thing. Let's break down the some key terms. So equality before the law means that every person, be it a citizen or non-citizen, it's subject to the same law. Equal protection of law ensure that the state does not discriminate against any person or group. This is a right that can be claimed by any person, whether a citizen or a non-citizen or Indian soil. Here we can find that Article 14 comprise two expressions which are equality before the law and equal protection of the law. The first expression, equality before the law, is borrowed from the English common law, and equality before the law borrowed from the English common law, and expression equal protection of the law is borrowed from the Constitution of United States of America, Section 4. I think it borrowed from there. Okay. So meaning of the equality before the law. So what is the meaning? Let's see. The concept of equality before the law simply means that the law must be enforced and administered equally among those who are equals. The right to sue and to be sued for same action must be the same for all subject to the age of majorities and maturity without any distinct on the ground of race, religion, caste, social status, wealth, influence, etc. So that's mean the concept of equality is equal for all. They are not discrimination on all these ground like race, religion, caste, social status, wealth and influence. इन लाइक इन ग्राउंड के ऊपर आपके साथ में कोई डिस्क्रिमिनेशन नहीं किया जाएगा. लो सबके लिए इक्वल होगा. आर्टिकल 14 guaranteeing similarities of the treatment and not identical treatment throughout the face equality of law. It simply means that there is an absence of a specific privilege on the basis of the birth or class or any such ground that favors any subject. It also implies that everyone shall be subject to the same jurisdiction. Okay, so exceptions of equality before the law under Article 361. So जो इसके exceptions है Article 361 के, these are given under Article 361. So the president or governor or of any state is not answerable to any court for the exercise of their duties or power. So जो आपके प्रेसिडेंट है या गवर्नर है किसी भी स्टेट के, दे आर नॉट आंसरेबल टू एनी कोर्ट ऑफ एक्सरसाइज टू देयर ड्यूटीज और पावर. वो अपनी ड्यूटी करते हुए अपनी पावर को एक्सरसाइज करते हुए किसी भी कोर्ट को आंसरेबल नहीं होंगे. So there is an exception of this Article 14. Second, the president or governor of a state shall not immune from having any criminal proceeding institute against them. और जो प्रेसिडेंट है या गवर्नर है किसी भी स्टेट की, उनको इम्यूनिटी मिलेगी, उनके अगेंस्ट कोई भी क्रिमिनल प्रोसीडिंग किसी भी कोर्ट में नहीं चलाई जाएगी, इंस्टीट्यूट नहीं होगी. No court shall issue a process for arrest or imprisonment to the president or the governor of a state during their term. और कोई भी कोर्ट प्रोसेस ऑफ अरेस्ट या इम्प्रिजनमेंट किसी भी प्रेसिडेंट या गवर्नर के अगेंस्ट नहीं इनिशिएट करेगी जब तक वो अपने टर्म में है, जब तक वो गवर्नर है या फिर वो प्रेसिडेंट है. नो सिविल प्रोसीडिंग इन which relief is claimed can be initiated against the president or the governor of a state during their term without giving a prior notice of 2 months. And कोई भी civil proceeding विच इज रिलीफ क्लेम कैन इनिशिएटेड अगेंस्ट द प्रेसिडेंट, जिसका जो क्लेम है वो इनिशिएट किया गया है प्रेसिडेंट या गवर्नर के अगेंस्ट किसी भी स्टेट के ड्यूरिंग देयर टर्म विदाउट गिविंग ए प्रायर नोटिस ऑफ 2 months. Okay, so this is the exceptions. There is more exceptions, like there is a 4 exception under section 361, and there is an additional exception which is given under like 360 a 361a. So additionally, as per the 360 article 361a, no member of the parliament or state legislature is obliged to appear before the court in any case of criminal or civil while each session is going on. So जब उनका सेशन चल रहा होगा उस टाइम पे कोई भी like member of the parliament or like the member of legislature, they are not obliged to appear before the court. Okay, as per the article 105 and 194, no matter member of parliament or state legislature is answerable to any court for the speech, opinion or vote given in the house. So अगर कोई भी ओपिनियन या कोई भी स्पीच उन्होंने हाउस में दिया है, उसके लिए उनके ऊपर लाइक कोई भी केस लाइक डिफेमेशन का है, कोई भी केस उनके ऊपर रजिस्टर्ड नहीं हो सकता. सो यहाँ पे उनको एक तरह से लाइक प्रिविलेज मिली हुई है अंडर आर्टिकल 105 and 194. So no member of parliament or state legislature is answerable to the court for the speeches which is then given in the house, okay, during the like discussion or session. Additionally, foreign sovereign diplomats and ambassador cannot have any civil or criminal proceeding instituted against them. This is something that accepted on a global level. और जो एडिशनली क्या है, जो फॉरेन सॉवरेन है, जो डिप्लोमेट्स है या एम्बेसडर है जो हमारी एम्बेसी में है, उनके खिलाफ भी कोई सिविल और क्रिमिनल प्रोसीडिंग इनिशिएट नहीं की जाएगी. Meaning of equal protection of law. The expression equal protection of law is a positive one, unlike equality before the law. It simply means that all persons in similar circumstances shall be given the same right and liabilities. This essentially means that equals are be treated equally and there must be no discrimination among them. Equals and unequals cannot be put in the same footing and to be treated without discrimination. So reasonable classification and exception of article 14. So article 14 में उनका है कि there is a reasonable classification. So what it is, let it see. The classification must be not be arbitrary. There are some rational or substantial reasoning behind the distinct drawn between the people who fall into the class and the people who do not. So there is a reasonable classification, like the special class of the people can be treated differently, but not the arbitrary. There is a substantial reasoning behind that. Okay, so there has to be some rational object behind the classification that the legislation seeks to achieve. The classification can be on the basis of various factors like geography, age, occupation. It is only required for the subject to the legislation to match with the classification. Right? The doctrine of reasonable classification allow to the state to the classify individual or object for the purpose of the legislation, but such classification must meet certain criteria to be considered valid. Here at the ground of the reasonable classification under Article 14. So, intelligible differentia. So, what it is, let's see. There must be a clear and intelligible difference between the distinguished person or thing that are grounded together from that and left out to the group. The differentia must have rational nexus with the object thought to be achieved by the law. Now, next, the classification is given rational nexus with the object of the law. The differentia which form a basic classification must be have rational nexus with the object sought to be achieved by the law. The classification should not be arbitrary or co- uh, capricious, but should be have the reasonable relation to the purpose of the law and substantial and not like illusionary. So the differential should not be trivial, that it should be result to a in illusory classification. That means like imaginary classification. It should have some reasonable basis and to be substantial in the nature. Okay, and public interest. This is also an important factor which should be in mind while we are classify the reasonable classification is there. So the classification should be in the interest of the general public. It if it is served a legitimate public purpose, it is more likely to be considered reasonable. Okay, and necessity of the classification. The classification must be necessary for the achieve the purpose of the law. If the same object can be achieved without classifying the individual or object, then the classification may be deemed unreasonable. Okay, now, example of the Article 14 in practice. So, to understand how Article 14 in practice, let's look at the some real world example. So, what it be? Whether it is a right to education, like employment opportunity, or even legal proceeding, Article 14 ensure that the state treat everyone fairly and without discrimination. Okay, and to appreciate the significance of the Article 14, we must understand the historical context of which it is was formed. The farmer of the Constitution were deeply committed to created a just and uh, egalitarian societies after the struggling of for the independent. So हम लोग सब equal हो and like किसी को because we got this independent after so many years and so because of that like there's the importance of the article 14 like everyone should be treated equally. There should not be discrimination on the basis of the race, caste, or like all these bases. Okay, there's a reasonable classification that's okay, that's allowed. So challenges and the criticism. While article 14 is a powerful tool to ensure the equality, it is essential to acknowledge the challenges and criticism it faces. Some argument that despite of the constitutional guarantee, disparities still exist in the various aspects of the Indian society. So thanks for the watching the video. Thanks for joining us on the exploration of the Article 14. If you found this video insightful, don't forget to like, share, and subscribe the channel. Until next time, stay informed and stay informed. Take care of yourself.